Excuse me?
What was the last words?
On these kinds of cases. So you decide, somebody sued me, they got a judgment, they're threatening to freeze my bank account. I'm going into court. I want to ask that, I never heard about this. I'm going to ask the judge to reopen the case. I want a chance to tell my side of the story. You need to show two things if you're going to go into court and ask to reopen a default judgment. You need an excuse. Why didn't you come to court that day? Well, I never got the piece of paper, Judge. Or I got the piece of paper, but I was in the hospital for 6 months. I couldn't take care of anything. You know, what's the reason? You have to have a reason. And then you need what's called in the law a meritorious defense. Okay, so you didn't get the piece of paper, or you were sick. Why should I open this case? What are you going to tell me when I reopen this case? Judge, I'm going to tell you I paid this. I don't owe this money, or I paid some of it, or this is not my debt, this is my daughter's debt, or whatever. You have to have a reason. You can't just go in and say, please reopen the case. You have to have a story to go with it. So now we're at the point where we're going to talk about dealing with debt collectors. You have rights. You have responsibilities, but you also have rights. And every level of government has some set of rules that state what your rights are. At the New York City level, sorry, at the city level, there are rules and regulations. At the state level, there's an Exempt Income Protection Act that protects your Social Security and other government benefits. And somebody mentioned here earlier, in the New York statutes, there's the code calls for notice and an opportunity to be heard. Welcome, have a seat, join us. Thank you. And finally, at the federal level, there's something called the Fair Debt Collection Practices Act, and that like shakes a finger at the debt collector. It's a no, you can't do that, you know. So we're going to talk about each one of these individually. And any questions before I jump into this part of the program? Okay. So in New York City, process servers, I have a feeling all of you have heard the term sewer service. Okay, so you know, process servers make money on the service that they perform, and the money is in the volume. So they might try to say that they served 40 summons and complaints in one day, and sometimes they'll say they serve 40 in an hour, and sometimes they serve those 40 in 5 boroughs in an hour. And if you're paying attention, you realize that's a little difficult to do. So the City Department of Consumer Affairs and the New York City City Council examined what was going on with process servers in New York, and they said, no, you're not going to fool us into thinking that you were in 5 boroughs in 1 hour and served 40 different people. You have to carry a GPS now. We want to know where you are. We're going to get a track record on where you are. So that doesn't directly impact what you're going to say to the court, but if you have a free attorney or you know how to challenge the process server, and I'll tell you a little bit about that, you know, you can find out ultimately, and they have to report on where they've been. They have to keep their records. They have to file them with the Department of Consumer Affairs for a period of, I think, 7 years. They have to hold on to their records now. So that industry is now being watched. So you will no longer, so the likelihood, and it's called sewer service because what they might do is serve the first one and throw the other 39 in the sewer and swear that they served all 40 of them. So no longer are they're trying to cut back on the abuses generated by sewer service. The debt collection industry is being regulated in New York City. So they now have to give you a callback number if they leave you a message. They have to provide the name of the agency, the original creditor, a person, the name of a person to call back, and the amount of the debt. I don't know about any of you, but I've been on hold a lot of different places where I'm trying to get information. And, you know, what do you get? In the end, you get a menu, and, you know, we'll call you back. And so debt collectors in New York City can't get away with that. They have to give you the name and a number and who to speak to. If you reach a settlement with a debt collection agency in New York City without going through the court process, they have to put the agreement in writing within 5 days. And if they don't, you call the Department of Consumer Affairs or dial 311 and ask for the Department of Consumer Affairs and say, I didn't get my agreement, and 5 days have passed, and now they're calling me again to pay this debt. They have to stop contacting you if you ask them to in writing. And they have to let you know, see, if the statute of limitations, which we talked about earlier, has expired, there's no law in New York that keeps them from calling you anyway. They can continue to harass you after the statute of limitations has expired. And what most people don't realize is if you try to appease them and say, all right, I'll send you a little payment, the 6 years starts to run all over again. So in New York now, they have to let you know that the statute of limitations has run on this old debt that they're trying to collect. So another little piece of information so that you know if you ever get a call, you want to know, is this an old, I don't remember this debt. Why are you calling me about this? You may not remember where you were 6 years ago. And they have to let you know. Please join us. There are a few open seats still. So at the state level, this is where the protection for your Social Security comes in. At the state level, there's an Exempt Income Protection Act, and the legislature decided that they didn't want to impoverish people just to pay back their debts. So if a debt collector went through and got a judgment and is now trying to freeze your bank account, certain assets in your bank account are exempt from being frozen. And it's currently $2,625. The first $2,625 of your directly deposited government benefits are exempt from the debt collectors taking them. And that's so even if they take everything else in the account, you know, you can pay your rent, you can get your prescriptions filled, keep the heat on, pay your phone bills, and work it through until more money comes in. Unfortunately, my limited experience anecdotal experience hearing from people is the banks don't know about this exemption, and you're the one who has to call the bank and cite the statute to them and tell them, you can't freeze my entire account. You have to give me the first $2,625 because you know that's my Social Security check. And there are other benefits, and I will give you the list. So there's another category of exemption, even if you're, so this is the first 26, I'm sorry, the number just recently changed. It was more like 2,100, and so you see it, I do say two different numbers there, but it's in the $2,600 range. It's, I forget which is the exact, I think the 2,625. If they're directly or electronically deposited funds and reasonably identifiable as exempt, like the bank knows from their records where that source is coming from, they came in within the previous 45 days of the creditor serving a restraining notice, those assets are exempt. And even if you're not getting if your exempt assets, if your benefits are not going into the bank, but you still have some cash in the bank, the first $1,740, no matter where it comes from, is exempt. Also, if it's been in there for the past 45 days. And that's based on the federal minimum wage and goes up every time the minimum wage goes up. So exempt income constitutes things like Social Security, retirement benefits, disability benefits, child support, you know, things that you would expect, government benefits, VA benefits, public assistance, railroad, black lung, you know, any sort of pension. The feds also, yes?
Public assistance, that's exempt also?
It is in New York.
Because they could put a lien on your house if you collect public assistance.
Who's the they in this?
Social Security, the Social Services Department.
Well, that's a little bit different than what we're talking about right now. We're talking about unpaid consumer credit. So we're not talking about social services liening. We're talking about debt collectors trying to collect on your unpaid debts. And public assistance is exempt to the limited extent I'm talking about here today from them freezing your bank account. You have to be able to get money from your public assistance deposits into your bank account so you can pay your medical bills, your rent, and your whatever, your utilities, until you straighten out what's going on with the debt collector. So it's a little bit different. It's not about you know, leaning your house in order to get back public assistance benefits that you weren't entitled to. I hope that answers. But you may owe. They may have a lien on your house for something else. For
How long do you know how long that lasts, or should I ask you that later?
be more specific.
Do you know how long
The freeze, the exemption lasts.
Yeah, the money's to be collected.
It's yours. The first sum of money, the first $2,600 is exempt. As soon as the restraint hits the bank account, they cannot have that. If more money comes in later, they can have that. They can have whatever comes into the account later. But the first $2,600 you can have. They have to give that to you. So you have some money to live on while you're straightening out your dispute with the creditor. They can't take everything. All right, it's been a lot of information, and I just want to get a sense of timing here. I want to leave time for more questions because it's so much information. So I'm briefly going to go through the next few slides and get us to the point where if you have questions about what we've talked about, there'll be time for that. So the Fair Debt Collection Practices Act is the federal law that shakes a finger at debt collectors and says, you can't harass people. You can't threaten to take away their children. You can't threaten to have them deported. That's not what you can do as a debt collector. And they have to notify you that they're trying to collect a debt. You get that first phone call, they have to send you a statement in 5 days of what that phone call was about. And then there's a whole process. You have the right to object to them making collection efforts, and while they're researching your objection, they cannot collect from you. They cannot try to collect the debt from you. So that statute is called the Fair Debt Collection Practices Act. And if you're having problems with a debt collector, there's a provision in there where you can sue the debt collector. Attorneys will take this case for free because this is one of the situations where if they win, the creditor has to pay you your legal fees. And that's even if you owe them money. If they're harassing you or violating the statute, you can still sue them. So then there are questions about, should I negotiate with my creditors? And I just, know what you owe. Know what you owe. What are your finances? Never get into a negotiation with a creditor to pay something off from money you don't have or have to borrow from somebody else. Ask for supervision from the court if there's a lawsuit involved. A lot of people go into the back room with the bank's attorney and reach an agreement, and nobody reviews it. And there are court personnel who are paid to review settlement agreements before the judge signs off on them. So ask for help if you wind up in any of these situations. Get it in writing, get it signed by both sides, and never agree to a provision that says, if I miss a payment, you can get the other $30,000 directly. No, you want to be brought back into court, even if you've reached an agreement. Let's say you miss another payment. You want an opportunity to come in and explain to the judge what happened and maybe work out a new arrangement. Be aware of, high pressure tactics in the court. You're nervous. You don't know what's going on. You're very unfamiliar, and they're as comfortable as if they're in their own living room. So be aware of that disparity in your comfort level, and don't agree to anything without getting some input or asking the judge for time to think about what the offer has been. And then I talk about preparing to go to court. You all have your own records. Organize them so you know what's in your records. If you're having a dispute with a creditor, go back and find your bills. If you're comfortable on the internet, go online and find your account and find it's a relationship. And you're going to want to be able to explain when you're in court the nature of the relationship and how, when you were meeting your responsibilities and what's happened while you're not meeting them now. Because trust me, the bank will have an explanation for your relationship, and it's not going to be a pretty one from their perspective. And gather your evidence, gather your documents, get organized, And then literally write out your story. Why? You know your story. Why should you have to write it out? Because honestly, when you're there in front of the judge, if you're like me, it all goes out the window. You can't remember, you can barely remember your name.